because to hear what, instead of me just talking, it's like, what are people actually encountering? Like, where are they sort of disconnecting with what's going on or have questions and all? So I think that's good. So whether it's chatting or people raising their hands, you know, maybe, you know, and actually, like, part of it is I want people to think about this, and it's sort of actually set up because I kind of model this a little after my classroom stuff at the law school. It is supposed to be set up to be a little interactive because that's the way we do things.
I think do whatever feels natural to you. I will play kind of like intermediary, and we'll just take it from there. I mean, I love our students this year. They're all amazing. We have a great distribution. They're super excited about their projects. And I think that this specific topic is something that everyone, not just people who have, you know, who are like fresh and new, but people who've tried to understand IP and understand how to move forward with that. It's just an ongoing topic. It comes up all the time at the garage. So I'm going to let you guys take it away. I'm going to mute myself, remove my video. If you need me for anything, just let me know.
Sounds good. Okay. Great. I'll start then. And when you say the tie, you said the sort of the tie, what was that referring to, Arcelia?
It's the Office of Technology, Innovation, and Entrepreneurship through Viterbi School. Oh,
it's through Viterbi. Okay, great. All right. Okay, well, we'll start then. So, hi, everybody. I'm just sort of, yeah, Arcelia, your picture's coming up here still, and I don't know, maybe, oh, you're on mute though. So, see what happens there. Okay. So, hi, everybody. My name is Rick Friedman. I'm a lawyer, and I've recently started a law firm called Novus GC. And what we specialize in is working with early stage companies, both on the corporate side of getting companies formed and helping with financing and a lot of basic legal needs, as well as a lot on the intellectual property side. And I teach a class at the law school. It's called Technology Transactions. And it's a class about really IP basics and about licensing and transactions in IP. And I've spent a lot of, like, I've worked a lot at law firms, but I've also worked in technology transfer at USC Stevens and at UT Austin. So my background is I'm not an engineer. I'm a humanities major, and but I've been doing this. I've been sort of in the tech world since graduating from law school in 1987 and moving to the Bay Area then, and working in Silicon Valley, and worked in Austin and worked in Los Angeles, all in basically in and around the tech sector. And so I'm not a patent lawyer. But I spend a lot of time working with clients on patents, more on the licensing aspects, and what I like to think of from a general counsel aspect of kind of advising people, you know, what it is and why they need it. And that's also what I cover in the law school class, is giving lawyers a kind of a basic understanding, to the extent they don't already, about the IP basics and how to transact in them. And it's a little bit, you know, there's just a lot of, we'll get into it, there's like a lot of misconceptions, and kind of, this is really supposed to be a fundamentals class to just sort of let people kind of start getting their heads around it, so they know intelligent questions and understand the differences. And I'm not going to make anyone experts in this class, but you know, the idea is to whet your appetite and get you headed in the right direction. So that's me, and like I mentioned, we started the law firm about 3 months ago. The law firm right now, although we're hiring now, the law firm right now is, it's me and Rebecca. And Rebecca, you want to unmute and get your video on and say hi and introduce yourself?
Sure.
Mind me put you on the spot.
Hi, everyone.
So I'll introduce you, Rebecca.
Oh, yeah.
Rebecca's a paralegal. Rebecca's background is a litigation paralegal, and now she's joined the law firm as paralegal and as our operations manager, and is making sort of everything work and run. And so, and is here with us today. Thanks, Rebecca.
Yep.
And so, you know, I'm going to start by, I'm going to pull up, I guess I'll share screen and share screen. Okay. I'm going to share screen. see what happens when I do this. Okay. So right now you should probably see a blue screen, I hope.
Yes, we do, with one file floating in the middle of it.
Okay, perfect. I should have gotten to the beginning of this. Okay, so this is it. This is the slide deck, and I may comment kind of in and out of this slide deck. So this is what we're covering today. And again, I do encourage you, raise your hand or chat your question if there's something sort of pressing, and we'll definitely try to get to your questions. So we're going to look at a few case studies. We're going to just talk about intellectual property principles in general, and then we'll talk about kind of intellectual property as it sort of intersects with product development, which I think is where a lot of you will be as you're starting to think about, oh, I'm developing this thing, like, how do I think about intellectual property? So I'll start with some case studies, and I'm gonna start, let me stop sharing for a second. So I often, like, you can see what I have in my hand here. This is like the first case study. I do it in my law school class. It's good. What it is, does anyone recognize this? I know it's a little hard to be interactive on when we're doing in this format. This is a dog bowl, and it's, as you saw from it, it had some bumps on the bottom, and it was trying to solve a problem. The problem that they're trying to solve by this dog bowl is that dogs, if left to their own devices, eat really fast, and they can end up having stuff go down their lungs, and that can create serious illness. So the idea was to solve the problem is create a dog bowl that they can't eat from so fast. And by putting these like bumps in here, it creates obstacles for them eating. So that's the idea of this dog bowl. And so, I start with this question of, so someone's got a product idea, like a way to, help dogs from choking themselves. And by the way, if any of you are dog owners, you might recognize the shape of this. There's a thing called Kong that people use as a dog toy, and this is the shape of Kong, and this is, made by Kong. So they have a product idea and designs to build a product. And the first question I have, is, are you required to obtain intellectual property rights to make and sell a product? Like, is there something you have to do in order to make and sell product? And kind of what do these even mean? And I guess I'll sort of, cut to one answer immediately, which is you don't have to. Like, in order to go make and sell a product, there's not something that says you have to get a patent, you have to get copyrights, you need trademark, this and that. But there are some things you have to do, which is avoiding using other people's intellectual property. And by getting intellectual property, you might be creating some competitive advantages for yourself. And so through this, we'll talk about what this means. And when we talk about, trying to get my, we talk about, there we go. When people talk about intellectual property, they generally talk about 4 different categories of laws that are all completely separate. Copyrights, trademarks, trade secrets, and patents. And people tend to lump them together. And what I'm hoping to do today is to kind of explain why they're very different and in what circumstances you think about them and may be interested in them. So, so we're going to back up. So backing up to this dog bowl, as we look at these different things here, and there may be some different aspects of it. Trademarks are something, and we'll talk more about this later, that protect names and logos and that type of thing. And there is Kong on here, and this Kong is going to be trademarked, so that will provide some protection. For reasons we'll talk about later, this is not copyrightable. And when we get to trade secrets later, we can talk a little bit about, there might be some things about manufacturing this that they had some special way to manufacture it. But when you look at it and you're an engineer, you probably say, well, anyone can manufacture that. You would create a mold and you would just, create this dog bowl. That's very, very simple task. So given that they've created something which is very simple to replicate, is there a way to protect people from knocking this off? And just once that, we put this out on the market, or when Kong puts this on the market, that other people can't come along and steal it, or not steal it, or just use the same idea and compete with us. So that's where we get into the idea of patents. And we're going to spend a little time on patents just because often they're the hardest to understand and for people to get their heads around. So this is an area, and this is the reason I talk about this, and I bring it up and I use it in my law school class, is because it's a fairly, on one hand, it's very simple. It's a fairly simple invention, but they have applied for patents on it, and we can learn something just about patents by looking at what we've done here. And just very generally, the idea of a patent is, and we'll get into more of the specifics later, but it's something that you can apply for with the government. And if you get it granted, you will get a monopoly, which allows you to exclude other people from making your invention. So the idea of applying for a patent on this would be, if we can get this patented, whatever that means, then when someone else tries to make a dog bowl that competes with us, we'll be able to stop them, because this monopoly right from the government allows us to stop other people from practicing this thing we've invented. And at the heart of patents are the idea that you've invented something. And in this case, Kong would say, we've invented this dog bowl that's really useful for slowing dogs down so they don't choke and aspirate when they're eating. So the interesting thing about patents is, you could say, well, okay, there's an invention, but what does it mean? Like, if I get a patent on this, what does this actually stop someone else from making? And I guess I wanted you to say, well, if someone created something completely identical to this that looked and was exact same mold and everything, that, well, presumably the patent will stop them from doing that if somehow we describe what it actually is that this invention is. But on the other hand, patents can be something broader, where if you've created something more generalizable, you can say, you can protect that idea more generally. Because as you look at this dog bowl, you can say, well, the thing that stops the dog from choking, may not be the exact curvature of all the little bumps on the bottom, but the fact that we put bumps on the bottom of the bowl. Because once I put this dog bowl out and people see that it'll stop dogs from choking, like, people might, try to change it to compete with me. So if, for example, if I were going to file a patent, and a patent is all, we'll talk a little later, it's all about the claims in the patent, that I want to create a patent where it creates broad protection, so that other people, when they try to create another dog bowl, they won't, they competes with me by putting bumps on the bottom, they won't be able to do it. So my ideal patent in this case would be, and this is kind of, I'm not a patent lawyer, this is sort of very lay explanation, but it's like, I'm claiming that I invented a dog bowl with one or more protrusions on the bottom. That way, yeah, I've got my unique thing here, but then if someone else puts out a dog bowl with other bumps on the bottom, they can't do that because I invented this idea. So ideally, in this kind of case, that would be a really valuable patent to get to help avoid competition. Now, what happened in this case was, that's not actually what happened. And by the way, I'm going to share these slides, and so there's no reason to be sort of writing any of this, anything that's on here you'll be able to see later. I'll give RC access to these. But what we see here is, when they actually went to the patent office and they submitted a patent application, and they went through prosecution of the patent, what the patent office determined was not that they were the first person to invent a dog bowl with bumps sticking out of the bottom, but it's something much, much more narrow than that. And in fact, there were already other dog bowls out there were like that, or there was what we call prior art, with bowls with protrusions coming out of the bottom. And when you read through this, what you read is that it's actually, and I'm not going to go through it all in detail here for the sake of the class, but it's actually something much narrower. And it's something where there's a central protrusion, where there's rounded surfaces, where there's a couple rounded surfaces of different sizes. And actually, even on the bottom claim, the bottom element of the claim, it's where in the part occupied by the protrusions is greater than the area that's not occupied by the protrusions. And all of this was necessary for Kong to get a patent, because there was prior art out there. There was other dog bowls that had protrusions out of the bottom, and the best they could come up with was, narrowing this to the extent that something that is going to actually end up being fairly similar to this, based on the basic geometry, based on having different size bumps, and all of those things that, yes, Kong was the first one that did those type of things, but there was lots of other dog bowls out there. So, in the end, it's, Kong can stop someone from knocking off like an identical dog bowl, but they can't stop other people from making slow feed dog bowls that have protrusions on the bottom. So I want to just kind of give that as kind of background of the way patents work, and the way patents work based on having to actually identify what you've been done differently that no one else has done before. I'm going to go on to the next slide. And here's another one. This is one, kind of use this as an example of how ideas are protectable or not. And this is a case, this was actually a very large litigation. Some people may be familiar with these dolls called Bratz. The person who came up with the idea for Bratz worked at Mattel. And he came to the people at Mattel and said, hey, I think we can make a line of dolls that will be popular that are going to have this, I think they're described by these Bratz are just proportionally large eyes and heads, makeup laden and skimpy outfits. They all seem to have very long hair also. And Mattel basically said, no, we're not interested. We don't want to develop this idea, which was just an idea at the time. And what happened is then this employee went to work at a competitor called MGA Entertainment that made the dolls. It became hugely successful and very competitive with Mattel's Barbie. And Mattel sued MGA, and initially Mattel won and won a very large judgment that this was theft of this idea. But ultimately it was overturned at the appellate court, and the judge ruled that Mattel can't claim a monopoly over fashion dolls with a bratty look or attitude, or dolls sporting trendy clothes. These are unprotectable ideas. So I bring that up also for you to think about that, when you have just something you say, I have an idea, is you have to kind of look more behind it, because an idea in itself is extremely hard to protect. If you're implementing an idea, you might through non-disclosure agreements be able to get people, to respect the confidentiality of that, but ideas alone are difficult. That's why we often have to look at how do we really understand what are these different categories of intellectual property and how do we fit in them so we can actually protect our business. The next example I want to just put out as a case study is this thing called Phantom Alert. And in Phantom Alert, the reason Phantom Alert is really interesting is that Waze, Phantom Alert is this traffic app that alerts drivers to driving conditions such as traffic enforcement monitors, hazardous conditions, speed cameras, what they call points of interest. And so Phantom Alert gathered up all this data about these points of interest to help people who use the app avoid, speeding tickets or hazardous roadways. And what happened is, well, they alleged that Waze got access to their entire database of points of interest and implemented it inside Waze. And so after the acquisition of Waze by Google, Phantom Apps sued Google over this, basically saying, you stole, we collected all, we had this whole database of points of interest and you stole it. And it's an interesting case. And what came out of it was that this was a copyright question, whether this entire database was copyrightable. Because one of the things we'll talk about when we get to copyrights is that facts are not copyrightable. If something, the fact that X and Y is true, that a fact's not copyrightable. But if you create a database and have some creativity that goes into it, the entire database can be protectable. What it turns out, though, is that's a very hard way to protect the data. In this case, although the court found that there might have been some value in the overall database, they actually didn't find that there was actually evidence of the theft of it. This ended up getting settled. But it's interesting now because data and databases and people collect vast amounts of data, which they think are going to be incredibly valuable. how you think about protecting that and monetizing it could be an important point of your business strategy. Here's one. This is kind of a little more of a fun one, which is, where's the IP? And the IP is actually on, Kobe's and the other players' arms right here, in that those tattoos are actually the art, the design in that tattoos is actually owned by the tattoo artist. And so unless there's another agreement in place, when someone creates art, and even though they're putting it on someone's arm, that they actually still own the art. So what's happened in several lawsuits is, the first one happened in an NBA video game, where the NBA video game recreated on the players the tattoos, and they were sued by the tattoo artists by saying, hey, you can't do that. That we own the copyright in that tattoo. Yeah, we put it on someone's arm and they're allowed to have it on their arm, but you can't now take that tattoo and display it in this video game and then make money off of it. And there's been several lawsuits on that. And I'm not sure there's definitive law, but these are lawsuits which is from a really basic principles of copyright law. They may win, because when you're the artist and you create the art, you own it. And yes, you've given, Kobe the right to wear it on his arm, but that doesn't mean you've given video game, makers the ability to actually put that into their video game. And then the last one is, this is kind of a fun one and actually relates to computer science in a very somewhat significant way, which is, some of you may be familiar with this. This is a fairly famous case of, if you just search monkey selfie, you'll see plenty on it. But there was this British photographer named David Slater who traveled to Indonesia to take photographs of this endangered primates called Celebes crested macaques. And on one trip, he had left his camera out. He had set his camera up, and one of these macaques came up and just started clicking on the camera like hundreds of times. And it was like, there's like these amazing pictures. Like, this is a monkey selfie. This is a picture of a monkey taken by itself. And what happened is, he came back and he displayed all these pictures, and Wikimedia started, posting the pictures. And he said, no, you can't do that, Wikimedia. I own the copyright in these photographs. And Wikimedia said, no, you don't. You didn't take the pictures. The copyrights go to the person who is the photographer who took the picture. And you didn't take the picture. You said you didn't take the picture. The monkeys took the pictures. And they said, you have no copyrights in it. And they're probably right. And what happened then is PETA, I don't know if you're familiar with the nonprofit PETA that protects animals, PETA then sued, saying, you can't post the pictures, the monkeys own the copyrights in the pictures. And they actually got pretty far in this case, but then it was ultimately ruled that to be a copyright, you have to have human creativity. And so a monkey can't own a copyright in a photograph. So a monkey can't own a copyright in anything. And the idea, if you're going to have copyrightable expression, that it has to be human creativity that goes into creating it. And this exact thing has been now cited in AI cases, where you have something that if you have an artificial intelligence machine and it would generate something that you would think would have copyrights in it, it actually may not have copyrights in it, because it wasn't the product of human creativity. It was the product of a machine's going through its routines. So you'll see this. So there's real issues now in artificial intelligence about, if a machine creates something you thought might be a copyrightable work or a patentable invention, both the copyright laws and patent laws are pretty clear that it requires humans to be doing the invention or the creativity. So these are some of the, sort of interesting issues on the intellectual property front. So let me just pause right there. I'm gonna, I don't know, I can't see as I'm doing this either the chats or if any hands are up. So I just thought I would pause a second.
So there's a one question. How much does it cost to patent an invention?
Okay, yeah. So to patenting an invention is a process. And the process starts with making a filing with the patent office. And then there's a period of time where the patent office will have to actually to review it. And then when they review it, they'll provide comments. And it often is sort of like a 2 to 4, or I'd say 3 to 4 year period to get a patent issued. The overall cost will typically be about $30,000. And even if you're, a student starting out, you don't actually have to freak out about that number right now, because you don't need $30,000 at the beginning to do it. Now, on one hand, if you don't think the invention's ever going to even be worth $30,000, you're not going to have that much sales, then it's a waste of time to file the patent because it won't be worth it. But on the other hand, if you think you have a great invention that's going to have significant value as you develop it, you can start with an initial filing and see to progress it along. And there's something you can file called the provisional patent application, which you can often get on file somewhere maybe from $1,000 to $5,000. And then that creates a placeholder for 1 year for you to file a full patent application, which the full patent application kind of generally $8,000 to $12,000 to at least get going on it. So, sort of the short answer is over the several year period, think about $30,000, and that's just for US. If you're going to go worldwide, it's a lot more. And, if the product's significant enough, yes, you might do that. And again, a lot of those costs are down the road, so you don't have to figure that all out up front.
And we have a few additional questions from Anita. I just want to encourage Anita, if you're comfortable, to unmute yourself and ask them directly. Anita is a superhuman aerospace applicant for VSG. I'm really happy that she's on this call. So I'm not sure. Anita, are you there?
Yes, I unmuted. Thank you for that introduction. I'm definitely not going to live up to it now. But in an attempt to be human, per your earlier point regarding the dog bowl, is it the patent office's responsibility to determine that your patent doesn't violate somebody else's patent? Therefore, if you were granted a patent for your invention, can some other prior patentee sue you to say that it violates your patent?
Awesome question. Awesome, and we're going to get into more, but I'm going to answer it now, and then you will see more kind of about the answer to it. In order to get a patent, what you have to have done is, actually, let me go to that now. I'm going to, that is just such a perfect segue. I am going to go to the next chart, and I think we'll answer that. And if we don't, we'll circle back, Anita, to see, make sure we did. Because there's sort of, is kind of a first principle also, actually, patents don't violate other patents. And you will see what I say in a minute. And there's two principles I want to state initially. One is that patents don't violate other patents. And the second is, just because you have a patent does not mean you have freedom to operate. So you can get a patent on something, and what you might have created, no one else created before, and you're entitled to get a patent on it, but you may still need rights from other people. So the very simple answer is, just because you have a patent doesn't mean you don't need other people's patents. And I can just use a very simple example before I go on there, is when we looked at the claim set for, I'm going to go back to the claim set here for this dog bowl. It could have been that, I'm just sort of making this up, that if you see there's 1, 2, 3, 4, there's 5 elements in this patent. If someone else had already filed the patent on the first 3 elements, and I never read to see if that makes sense, but if someone else had patented the first 3 elements, but what was really novel to what Kong did was the 4th and 5th elements, then Kong can still get the patent because no one else had ever thought about doing the 4th and 5th elements. So they discovered that idea. But that doesn't obviate the fact that someone else already invented doing steps 1, 2, 3 and filed a patent on it. So what you said is just a great question, because it's like the biggest source of confusion, is a patent doesn't give you the right to do anything. A patent simply allows you to exclude others from doing it. And in this case, we could talk about, you might have what you have invented maybe an improvement or modification to something that's already patented, and that's fine. You can modify and improve it, but you still might not be able to make it without getting rights from that other party. Anita, does that answer your question enough for now? And if so, I'll move on.
Yes, thank you.
Okay, so that was a great, perfect question, and it kind of gets to a lot of kind of confusion people have about patents, but it's perfect. the one thing about it is, so intellectual property, we mentioned earlier, it's these 4 different areas. And the one thing about it is they're, most typically associated with patents, copyrights, trademarks, and trade secrets. And, there's this Wikipedia definition, which if we had more time, I could completely pick it apart on why it doesn't make sense. It's this idea that, creations of the mind. That's like not really, I mean, in some senses, you can say that patents and copyrights have to be quote unquote creations of the mind because there's that human element that we discussed, but trademarks and trade secrets don't necessarily to be, and they're just the way they came about and what exclusive means. It's sort of very different. It's what I find it's sort of very confusing to try to think of them together. And it's really helpful to try to separate them out and to have a meaningful conversation about getting protection. You really need to know what bucket you're in, and any particular product can be in several buckets. And we can kind of come back to that point. So intellectual property, the basis on why we have it in the country stems from the Constitution. And in the original Constitution, Article 1, Section 8, Clause 8, gives Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to the respective writings and discoveries. So this constitutional provision here is the genesis of patent and copyright law. This idea of, copyright is the writings and discoveries is patents. Interestingly enough, so the original Patent and Copyright Acts were passed in 1790. About 80 years later, Congress passed the first trademark law, and they cited this as authority to pass the law, and Congress actually found the law unconstitutional. They looked at this and said, this doesn't talk anything about trademarks in Clause 8. You don't have authority, Congress doesn't have authority to pass a trademark law. And there's actually another provision, so Congress went back and found another provision called the Commerce Clause and passed it under that. But it sort of like kind of gets to the confusion of the different areas of intellectual property law. So we're going to talk about, so generally, I want to spend a little more time on patents just because there's what I find is pretty widespread confusion, and there's like, it's really maybe anti-intuitive on how it works. But there's 3 kinds of patents: utility, design, and plant. When people are talking about patents, they're almost always talking about utility patents. And one of the things about utility patents is they have to be useful. Design patents are for purely ornamental things. So it could have been possible actually for Kong to apply for this on the basis of this being purely ornamental. And there's actually I found one other design patent by a slow feed dog bowl where they went the design patent route. But they didn't. In this case, Kong went for utility patent. And the last one has to do with plants, like, live plants and, people breeding plants. That's the last kind of patent. We're going to focus on utility. And like I said, 99 times out of 100, when someone's talking about a patent, they're talking about a utility patent. And as we talk, utility patent is the right to exclude people. If you get the patent issued to you, it allows you to exclude others from making, using, offering for sale, selling, or importing an invention. It does not provide freedom to practice, as Anita's question highlighted. Just because you get the patent doesn't mean you can practice it. What it means is you can stop other people from doing it, from doing your novel thing. Okay, and so the different elements, in the 4th bullet, we talk about the criteria that Congress has laid out for what it takes to get a patent, and it's got to be novel, meaning no one else has done it before. You actually are the person who invented it. Now, when you hear people talk about prior art is used to defeat novelty. That if you can show prior art, you can show you weren't the first person to invent it. One thing I also want to back up on this is that patent infringement is something that can be done completely innocently. There's no element in patent law that says you have to have known that you were using someone else's invention. So what happens is a lot is people are working on similar things and people invent the same thing. So it is a little bit one of these things of some riskiness where if you don't know what patents are out there, you might not be violating. You may be violating, you just don't know. For copyright, I'll take it for copyrights and trade secrets, you have to have something wrong to actually commit copyright infringement or trade secret misappropriation, because you would have had to have access to the copyrighted material and actually copied it. And same thing for trade secret, you would have had to have access and subject to a agreement of confidentiality and taken and misappropriated. Patents can be totally innocent. And that's like the power of the patent laws, that if you get the patent, it gives you this monopoly right to exclude others who even completely innocently come up with, the thing that you invented. So it's got to be novel, non-obvious. It needs to be useful. The useful bar is extremely low. This was useful. This was useful because it stops dogs from choking. There's, before they did this, there was plenty of other dog bowls that did something similar. Maybe this was marginally more useful, but this is a useful device. And it needs to be either a process, a machine, a article of manufacture, a composition of matter, or improvement of any of the foregoing. So those are what are considered patentable subject matter. And a patent is granted by a government authority after inventor files a patent application on a timely basis and prosecutes the application issuance. And prosecution can take several years, as we discussed. I'm going to keep going through another slide or two, and then I'll pause if anyone has questions. There's some really important things to know about patents if it's something that you're thinking about. Actually, one thing I want to back up on is that based on what you're doing, you may be working with things that are more or less patentable. And currently, generally, in the software space, patents are hard to get. And there was a time, I don't know, more like 10 or 15 years ago, that people were filing patents on all these business processes, and these were being liberally granted. And what happened is, with the Alice decision, and if you want to read more about it, you can read about Alice in terms of the test for patentability of software, it became much, much harder to patent software. And I think, as I mentioned, I don't have a technical background, but as the patent lawyers will often, have explained in kind of as basic terms as possible, what'll be patentable is having a technical answer to a technical problem. That's the type of thing that's going to get patent protection. And the law could change again. So some people argue, hey, that's the law today. It may change tomorrow. So, you may want to think about filing it just in case the law changes, because I'd say in the last 20 or 25 years, there's been 2 Supreme Court cases with each time completely changed the landscape of how people thought about the patentability of software. But when you get to patents, I'm not going to spend a ton of time on this one, but a couple of general things is that if you want to patent something, you're better off filing the patent application before there's been a publication of it. And, a publication doesn't mean necessarily, a publication, if you do get it published in a scholarly journal, that's absolutely publication. But a publication can be anything. It could be showing your invention at a poster presentation. It could be, there's case law about placing an index copy of a dissertation on a library shelf. Even if no one ever takes that dissertation off the library shelf, that is still actually the fact that it's indexed and on the library shelf is publication. If you talk to other people about it without having a non-disclosure agreement in place, that will be a publication. It's a very, this idea of publication is something that it's a lot of things you can do can be considered publication, and you're best off filing a patent application, whether it's just the provisional, before you tell anyone or show it. So that's the bar on publication. There's different time periods in the U.S. I'll let you read through these and ask any questions, but in the interest of time, the best advice is to file, before you do any of these things that are considered publication. But it's also can be important not only because of the technical rules, but especially when you talk to bigger companies, is, the idea that ideas themselves aren't protectable. Once you kind of plant the seed, what you're doing in someone else's head, especially a bigger company, they might go sort of spinning off in other directions and have ideas on how to improve it or different things, and they may go file an application. And I've seen that happen before, where bigger companies, meet with smaller companies. Maybe they even are under NDA when they meet, but they still go file a patent application. And then it's sort of this sort of difficult place that the smaller company is sort of somehow, trying to convince someone that this bigger company stole something from them, that they were considering a trade secret. The application process requires disclosure of the invention, and it needs to have enough in there so that someone practiced in the art can, without undue experimentation, repeat the invention. There's costs in there, kind of along the lines we discussed. The patent does have a finite life of 20 years from the initial filing date, and I don't know that I have it in here. I don't have it in here. Patents are freely searchable. All issued patents, you can go to uspto.gov to go search yourself and do different word searches to see what you can find. Google has a Google patent. There's a special Google patent page you can go to, which just searches the patent databases. That can be a shortcut way. And both issued applications are published, but patent applications are generally published 18 months after their initial filing. So you can't see all patent applications because there's this 18-month lag. And there's some exceptions that if you only file in the US, you can avoid actually publishing the patent application issuance. But generally today, most patent applications will get published after 18 months. There's two separate databases at the USPTO. You have to search both if you're going to do a thorough search, both the issued database and the patent applications database. Let me again take a breather and just, if there's any questions based on this. So actually there are a couple questions and I can address these. Yeah, so I think it's Vince. Asked the question about, is there a website to check patent rights to avoid using others? So yeah, there's the USPTO, which, where you can check. And again, it's not perfect because there is this 18-month lag. So there's always that risk in that 18-month period that something's been filed you don't know about yet. There's also, that's just the US database also. There's also the international organization where there's something, it's in the slides, I didn't go through it, but something called the Patent Cooperation Treaty, that if you file there, there's a centralized kind of international database. It's at WIPO, W-I-P-O, and I'm pretty sure it's wipo.org, and that's another centralized database of patent applications internationally. Okay, Anita asked, does the term novel mean not patented or not existing in the public domain? It means public domain. So if something is out there, just sort of publicly available, it's actually that someone else, it's actually not even in the public domain. It could be either or. It could be in the public domain that someone else has published the idea or demonstrated, or it could be another patent application that's filed prior to you, even though it hasn't published yet. Either of those would be prior art. And then Ian asked, if the license of the implementation source code of the model algorithm from the author is not for commercial use, then can I use the implementation, which is done by myself, for commercial use? Ian, can you unmute so I can get a little clarification on that? Let me know when you're unmuted, Ian.
Sorry?
Can you clarify, can you give me a little more background on your question? What's the, you have access to the source code already?
Yeah, for example, in the GitHub, there are so many implementation, and then some implementation from the research paper is not for the commercial use, like a Creative Commons license or something. And if I implement it by myself, then can I use that for commercial use? I was curious about it.
Okay. And as far as you know that that's not patented, right? Do you have any reason to believe that the algorithm is patented?
There is no, I guess there is no patent.
That you know about?
Yeah.
Yeah. I mean, you could always search to see if they filed on the algorithm, because the algorithms are one thing that can be patentable, because we talked about processes, a novel, useful process. And so algorithms, generally check the boxes of that. So people can, generally they don't, but it can be worth checking. You might do a search to see if you know who the authors are, who owns it, to see if they actually did file patents on it. let's do this, Ian. Let's talk about copyrights for a minute, and then we'll come back to your question, okay? Because what you're asking is a copyright question. Because from a patent perspective, if they haven't filed a patent on it, then it's not a patent issue. And so you guys are giving me these perfect segue questions. Because there's a question now, okay, we've got access to software, we get it on GitHub, and what can or can't we do with it? We've read the license. So let's talk about software, and then we'll circle back and talk about how, we'll talk about copyrights, and we'll circle back and talk about how that relates to software, which sort of in retrospect, I realized it would have been good to throw a couple slides in here about this. So having a little trouble advancing here. There we go. So this is the only slide on copyright, so we'll answer it all right here. The copyrights protect literary, dramatic, musical, and artistic original works of expression, such as poetry, novels, movies, songs, computer science, and architecture. It arises automatically upon fixing the original expression in a tangible media. The rights are not lost by publication. So, we talked about patents. In patents, if you publish, you actually do have 1 year grace period in the US, but in most of the rest of the world, you don't. You just lose your patent rights if you've published before you file the patent. But copyright's different. Copyright, you retain the rights. And once you actually create it and fix it in tangible media, so you type it up and you've got your, code or your essay or you take a photograph, whatever it is, once you've created it and it's fixed somewhere, then you have copyrights. They arise automatically. Now you can get stronger rights by registering them, and you will do that before you file a lawsuit. But in most cases, people don't actually register their copyrights. And as mentioned here, computer software is something that has copyright protection. And what copyrights protect is it provides an exclusive right to copy, prepare derivative works, public distribute copies, perform publicly and publicly displayed. So the thing, what copyright says you won't do is that you won't actually literally copy. Like copying says I can't take something and literally copy. What it doesn't prevent is from someone else creating the identical thing who didn't have access to it. So kind of the really just very, far-fetched hypothetical I use is, imagine someone's been in the cave the last 40 years and they had a typewriter and lots of paper. And in the last 40 years, they sat there and they pecked away. And after 40 years, they come out in 2020 and they hold this thick, this thick manuscript. And what it says is The Adventures of Henry Potter. And when you read it, it's word for word identical to Harry Potter. It's like the most incredible thing. Okay, some crazy thing. He got the exact same inspiration as J.K. Rowling and wrote the exact same book, but was in the cave and can prove he was in the cave for the last 40 years and had no access to it. The question is, did he commit copyright infringement? And the answer is absolutely not. In order to commit copyright infringement, you've had to have access to it. And so there's nothing that J.K. Rowling can protect other than copying her work. And there's other things like names and different things that can get protected, again, but people have to be copying it. And if you didn't have access to it, you couldn't have copied it. So, and again, this is very different than patents, as we discussed, because for patents, you can have completely innocent infringement. Copyright, you can't have innocent infringement. You have had to have access and copied it. So, so another important idea about copyrights is it doesn't protect ideas or functional elements. So, if I, for example, create a research, do a bunch of research and write a research paper that explains my invention to the whole world, the research paper itself is copyrightable. People can't photocopy and make copies and publish copies of my research paper. It's going to be done through a journal that's authorized to do that, and they're going to, I'll in the journal, whatever, will own the copyrights. But anyone can read the article and learn from it. And if I don't file a patent on that invention that I described, anyone can go use that invention. Or at least I can't stop them. I don't get the exclusionary rights by a patent if I don't file a patent on my invention. And just the fact that I put it in an article and copyrighted the article gives me no protection over the invention at all. And in fact, it's going to start my 1 year clock on filing a patent in the United States. So when you go to GitHub and you look at when you read some source code, if you learn from that source code, you're not limited in what you've learned from it. And so the question becomes, so to the extent that you want to keep something as a trade secret, you don't release the source code, because when you release the source code, you're using it, and that's an important aspect of it. So what you're doing generally, when you are using GitHub and you're publishing things, you are using the fact that you own copyright in that code, and you're using the fact that I already own the copyright in this code. I'm going to share it, but if you're going to access it, I'm sharing it under a license, and you have to obey this license. And if you don't obey this license and use this copyrighted code, copy it, or do things that you can do with copyright in a manner that's not compliant with my license, you'll be committing copyright infringement by doing that, by not following the rules I've set up. And we could sort of do a whole nother thing that sort of spends at least 30 minutes explaining open source software and how the open source licenses work, to understand the different, because there's different kind of licenses, and some are very permissive, some are restrictive. In your case, Ian, it sounds like you have a very, a much more restrictive license that's been posted on GitHub with respect to the software. So let me ask you this question. Now we've kind of laid the groundwork on that. What do you want to do with that software, Ian? You said, I want to understand what you're asking to do with it. You say you use the implementation. Now, if you're going to actually take that actual code and modify it, or put it into, as a module of something else, and it says that you can't do that for commercial use, only research issues, then if you were to use it for a different purpose, use that actual software, take what he's done, make modifications to it, and compile it yourself, then, and you didn't follow the license, you would be committing copyright infringement. And, in this circumstance, the two options are, if you were actually going to use his copyrighted work, would be to follow the rules of it, or it is also potentially possible to go back to the original author and ask for a different license. So it sounds like the author in this case has published the source code under, I think you said, a Creative Commons license. That if that person's the original author, they maintain ownership of it and can grant you different license rights, but you might have to pay for that.
If I don't take anything from their implementation, and then I just, after reading their paper, and then I implement by myself, can I use that implementation for commercial use? I mean, if I don't take any part of their implementation.
Yeah, one of these things, I try very hard to not give legal advice on these things. One is just because of the nuance and understanding of it, but it may be that you can, because you are allowed to, when you say their implementation, means you're not copying any lines of their code. So, let me back up one step on this, which is when people are trying, let me explain, if you were at a company, what I would tell you to do at a company, just so you can kind of get a general flavor of this. If you were at a company and you saw, and you had someone who had access to some software that was, and you wanted to do something similar, what you would do at the company is the person who had access, or someone could write a high-level specification for, I want software that does X, Y, Z, and have someone who doesn't. Now, is the algorithm explained in the research, in the published research paper?
Yeah, the algorithm, I mean, the model is explained in the research paper.
Okay, so the model is explained, and then did you need to go to the source code to actually understand the model, or was there like enough described in the research paper to allow you actually just to code it up based on that?
It's not detailed enough to implement just through reading the paper. I mean, yeah. So if I want to implement, maybe, yeah, I have to go to the their implementation.
Yeah.
Yeah.
This is one of these, I would call this something I'm not comfortable sort of giving you something you would rely on the fly, because kind of best practices when you've had exposure to copyrighted software and you want to code it up separately is that you have someone who didn't have access to it coded up, because you're in a position now where you've had access to it. That's kind of like the Harry Potter example. You can't claim you were in the cave for the last 40 years. You've seen their code. You know, there might be an argument that you did, you know, use that access to the code and what you've created actually is a derivative work. I would say that's a gray area. And you could maybe do some, you know, research on that one yourself, but there is some risk to it. If you simply read the research paper and there's no patent filing and it described the algorithm, then, you know, then there'd be no question. This creates a little more question in terms of the activities you do during the coding, whether someone could argue it's a derivative work of their work because you've basically, you know, seen what they've done and then followed what they're doing. Any further questions on that, Ian?
Yeah, I mean, it's okay. Yeah.
Okay. Any other questions before I go on? Okay, let me go back to screen share. Okay. Trademark is also something that can be done innocently. You can commit trademark infringement innocently. If someone has rights in that trademark, you know, even if you don't know about it, you can be creating trademark infringement by using a mark that is similar and can cause confusion. So it is one area where you know, at some point in your company's history, if you're developing products, something you need to worry more about. I generally counsel people when they're early stage not to worry a ton about it. One thing about trademarks also is, you know, you can get common law rights just by using the mark in commerce. You get much stronger rights by filing with the USPTO. But the one thing, there's this huge difference there's lots of differences between trademarks and all the other ones. Like trademarks can last indefinitely, copyrights have a finite life, patents have a, you know, fairly short life, trademarks can last indefinitely. The other thing about trademarks is trademarks are use it or lose it. You can file a patent and not do anything about it and wait, it lasts for 20 years, and you could wait 19 years and then go start suing people for everything that's occurred in the previous 6 years. You have 6 years to sue people. After 6 years, you can't go back more than that. But you can sue people for anything that they've done in violation in the last 6 years. You don't have to use it yourself, and that's when you hear the term patent trolls, and it's generally, you know, associated with people, the companies who don't actually do anything with the patents, but just sue other people to exercise that exclusionary right. Trademark's different though. Trademark, in order to get and maintain trademark rights, you actually have to use it in commerce. You can't squat on names and just say, oh, if I got all these great names, I'm going to file a bunch of trademarks, and then maybe I'll develop products or sell them to someone else. Not the way it works. You've got to be using them in commerce, and you can file before you're using it. You can file what's called intent to use, ITU, before. That way you can say, hey, I'm going to do it. Before I spend this money, I'm not using it yet, but I want to make sure I'm ready. So you can file that, and that lasts 6 months. And after that 6 months, then you can extend it for another 6 months or show that you're using it in commerce. And you can do that for up to 3.5 years. So, you know, it's the type of thing that if you're really early stage, you know, one thing is trademarks are a lot cheaper. You know, it's, you know, several $100s to file it. And it, you know, if you've got a nice clean mark, you know, it might not cost much more to get it issued. There's a lot of nuance in it, in trademark, the things, just to put up one thing out there, the less descriptive, the better. You know, when you look at things like Apple is such like an awesome mark because it's not describing what it does. It's, you know, it's so associated with Apple computers now, it's very protectable because it's not, you know, descriptive in any way. And a lot of times people will sort of like try to do things that are really descriptive, and they tend to be harder to get and much weaker marks in terms of protecting you from people doing things similar. And often when you do it, you know, at a later stage, companies will actually spend money sort of searching just to make sure when they're doing something that no one else is doing it, just because you can go file and then it's expensive to go file and find out that, oh, there's other already people in the US doing things similarly. Trade secret is, so trade secret is, you know, all these other things, copyrights, trademarks, patents, you can get sort of protection or more protection by filing. You know, trade secret, there's no filing. You don't file it anywhere. You keep it secret. That's the whole nature of trade secrets, is that you've taken these steps to maintain its secrecy, including making sure everyone signs non-disclosure agreements who've had access to it. Because if you don't get these NDAs, then people can argue it's not a trade secret. You're telling it to other people without NDA. And you know, it can be maintained forever. It provides no protection from a competitor developing the information independently. So if you develop an algorithm that does something really clever, and your competitor develops the same algorithm, they're free to use it. If they stole it from you, that's different, but they're free to do it. And that's where, you know, sometimes you get this question of, oh, if I patent it, I can actually exclude people from doing it. But sort of a longer conversation on why and when you patent an algorithm. And trade secret will last as long as you can keep it a trade secret. I've got a few more slides that I think are worth running through, but I'll stop sharing for a moment just to see if there's any questions on the basic stuff we talked about.
Yeah, I also want to just check in with the entire group and let you guys know, thank you for staying on later. I know that this is longer than you guys maybe have scheduled, but I promise you, spending time learning about these foundational basics on intellectual property is an amazing opportunity, especially with a lawyer who are pretty costly in the real world. So thanks for sticking on. I'm very happy to stay for the entire remainder and leave the Zoom call going for the entire remainder of your deck. Rick, it looks like we don't have any questions in the group chat, so you can keep powering through unless somebody wants to raise their hand and ask something live and have some feel brave. Otherwise, I think it's good to just jump right back into there.
Okay, and there's just, I think, 3 or 4 like substantive slides left. And I'll try to cover some practical things. I hope that this was practical, but some practical things just to think about for people when they're doing the products. And also as you're, maybe you're working for other people, and also sometimes people have questions of, oh, I'm employed by someone, how does that relate to all this? So, yeah, I've only just a handful of slides left. And so, as I mentioned earlier, so, you know, why worry about IP? You prevent others from copying what you're doing. You create barriers to competition, which can also be important if you go to investment, is that your investors are going to want to know, like, do you have IP? That's a common question. And when they say, do you have IP, it could mean anything. It could mean, but it's sort of up to you to define what that means and what your strategy is on how you're creating these barriers to competition. And it can improve the chance of being able to finance the project to the extent you have something protectable. You know, a lot of times the way the project is financeable is just you're really good at implementation, and that can be enough, that you've got a hard implementation project, you're doing it well, you're doing it right, you've got good partners, and that can be enough to finance it. But you will, you know, invariably you will get the question of what's your IP, you know, and just, you know, having some answer to it. And so how do you develop protect? And there's a few places to start. One thing is, if you remember the tattoo example from really early on, you know, we had Kobe's arm, and there was a tattoo on it. And, you know, Kobe paid somebody to put that tattoo on his arm, right? So you'd think Kobe paid for that tattoo. He should own it, right? And the answer is no, that's not the way ownership laws work. The way the ownership laws, basic ownership laws work, at least in the United States, and they vary from country to country, is that, you know, and patents are, and patents and copyrights are slightly different in this respect. The way the patent law works is, even if I pay you to develop it, even if you're my employee and you develop a patent, unless I've gotten an assignment from you, you, the employee, own it. So for that reason, when you go work for a company, they're going to have you sign a document before you start that says you assign your patents and other inventions to them and other stuff. But it's just important to understand that just because, hey, you think I've hired this person, I paid him a little bit of money, I own it, not the way the laws work. So really key thing, and this is, you know, investor due diligence. This is like very high at the top of the checklist. Do you have agreements with people who are providing stuff for your project and that is assigned it? And there's very standard form documents that do this, that can enable you to do it to you know, get ownership. But it is critical you get ownership. And when people are founding a company, typically what we do in that case is when we do all the formation documents, as part of that, the founders will sign some kind of services agreement where they agree that everything they're doing is getting contributed into the company. So that's the first thing. Written assignment is critical. You know, second thing is keep trade secret secret. And if you want something to be kept secret, you know, whether it's your source code or your plans, whatever you're doing, you know, keep it secret. Keep it, you know, safe on a protected place. If you're going to give access to it, have people sign non-disclosure agreements. And also, when you're talking to third parties and you want to get someone interested in your project, maybe an investor, so often the engineers and scientists feel like it's important to like explain what the thing they invented is and how it works and why they've solved hard problems to solve. And often that investor won't understand what you're saying and doesn't need to know that, at least initially. And so you know, often you can take this sort of like really like peel back the layers of the onion approach, where the first thing you tell them is, hey, I've figured out how to convert lead into gold. Okay, I've got a proprietary process. I put it in here, it turns lead into gold. I've actually been able to demonstrate it, and I'm writing a research paper on it now, and I'm going to show it. It absolutely works. That may be enough, you know, to get people interested. The lead versus gold, maybe that's not a great example, but you understand that for you know, a lot of investors, some will have the technical chops and will want to dig in, and then maybe you get non-disclosure agreement with them. But a lot of them, they may just need the headlines, and you don't need to really go into the technical detail. So that's something to think about in your projects, of getting people interested and on board without really, you know, revealing the secret sauce or giving them enough to like figure out to be able to do what you've done. You know, trademark protection, I'm not like super, I don't go kind of overboard on the trademark protection. If you're going to put something out there like an app that's going to go viral, then you want to be thinking about that. If you're doing something that's more B2B and you're going to have just a few customers initially, it may not be that trademark protection makes much of a difference initially. It just depends. And you know, patents are very specific to what you're doing. You know, I expect that probably no one on this workshop is doing, you know, drug discovery. If you were, patents are critical because of the huge investment required to get drugs to market. You have to have patents. You have to have that exclusionary right. You know, for most software, no, investors don't expect it. It's, you know, it's not worth the money. But on the other hand, if you've come up with like a really clever solution to a technical problem, and it may be patentable and help you create barriers to entry, it could be useful. Let me just check. I'm getting alerted to something. Oh, there's a couple of chat questions. Let me look at the chat questions. I'll just take a break right here. Yeah, so the question of if someone has access to the copyright work but has not seen the work itself, is it a copyright person if that person created similar work by coincidence? Again, no. If you do it by coincidence, it's not copyright infringement. The reason like access is important is if you can prove you don't have access, then you have this incredibly good defense when someone comes after you for copyright infringement. If you had access, but but didn't actually look at the copyrighted work, that's not copyright infringement. Copyright infringement requires copying. And if I had Harry Potter book that's sitting on my shelf and it was like with some cover on it that I didn't see the name of it, I never picked it up off the shelf, and I wrote it, and I wrote the exact same thing, I have not committed copyright infringement. Now, if someone sues me and I go to a judge and I try to convince the jury that I didn't do it, the jury may not believe me. That's why it's not copyright infringement if you really haven't looked at it, but there can be proof questions where, not having access is better than having access. So that's the technical answer to that question. And then it says, many investors will not, the next question from Anita is, many investors will not sign NDAs just to see a pitch. If you do not have a provisional patent application, are you then exposed? So this gets to that point I made, Anita and everyone, about, and that's true. Investors are generally, and certainly in the initial meeting, most are not going to sign NDAs. They see like hundreds of pitches. They worry about getting exposed to confidential information and somehow someone accusing them of using that confidential information for another company. So this gets back to this idea of peeling an onion, that in that first pitch, you really shouldn't tell them something that's trade secret if you can avoid it. That's like, look, I figured out how to turn lead into gold, and I've run, you might tell them, look, I've run experiments. You might show them some data from your experiments you've run, or show them to provide some credibility that I've done this. And coming from your backgrounds, you may have some credibility already, that the fact that you got to the investor. You don't have to prove to that investor in that first meeting your technical chops. They're going to assume you have the technical chops to do it. You don't have to show them your solution. So to answer the question is, think about giving them information that, and generally for the investors, they're not going to go send the deck off. It's unlikely they will, especially if you ask them, like, please don't share this deck with anyone. It's not like they're going to. What they may do, though, if they're interested, they may say, hey, I want to share this deck with my technical consultant. So it may they may have a technical consultant to look at it if you've given them more technical information to see if like what you said is possible or makes sense. And then, the question, if you do not have a provisional patent application, are you exposed? This gets to the question of, you would absolutely not want to put anything in that deck that was an enabling disclosure. Because if you put something in the deck that's an enabling disclosure and you provide that deck to someone without an NDA, you've actually just published it in the eyes of the patent office. So you could actually jeopardize even getting a patent by making these enabling disclosures. On the other hand, if you say, I turned lead into gold and I'm not telling you how, that's not an enabling disclosure. So, that's the sort of technical legal answer. Beyond that, what I would say is, if you can get a provisional file, that's even better. Because maybe when they hear what you're doing, people might kind of go off on ideas, and, investors are, I'd say, the least likely to do this, to go file their own applications. But we generally say, before you go talk to like industry partners, absolutely try to get a patent provisional filed. If Vince and Anita, I've answered your questions. If you have any follow-ups, feel free to unmute, but otherwise I'll go on.
I think you answered my question. Thank you.
All right. So, I've figured out how to keep the chat thing open. So I want to, you don't have to spend much time thinking about getting copyright protection because you get it automatically. It's not really a decision to make. You get copyright protection automatically. You do want to get assignment agreements. I'm not going to spend time. The laws are very different on employees and consultants and patents and copyrights. I'm not going to get in it. I gave you sort of a general law about patents, but it's just the one huge takeaway I want you to have is that you want to get people to sign patent assignments when, just very general IP assignments when you're getting them to do work for you. So, in deciding whether to pursue patents, there's first a question of, are you even able to get a patent? How crowded is the patent space? We talked about this patent, and not only is that sort of like the prior art space is crowded in this, the patent they got was very narrow. Is that really of any value to get a patent? How easy or hard will it be to design around your patent? We saw the claims for this, and we saw like there was a lot of different elements of it. And if you read through it, you're all engineers or engineering students. I guarantee you will all easily be able to look at that set of claims and find several ways you could change. You could do things to create a slow feed dog bowl that don't violate the patent. In this case, because there's so many elements of it, you could just change one of the elements and you wouldn't have patent infringement. Question about whether you can afford to pursue patents, and they can be expensive, as we discussed. But there's also a question: can you afford not to pursue them? And again, a lot of what you're doing is you're building devices, you're making software. In these cases, often you absolutely can afford not to pursue patents, because your investors aren't going to get, necessarily require them. You're often going to be patenting one narrow aspect of it. But like I said, in other industries, in pharmaceutical, biotech, if you're doing medical devices, those are areas where it can be more important to have patents, to be really critical to have patents in order to get investment. And generally, you want to, it's good to have a comprehensive strategy on how you're going to do it. One thing I didn't mention, we didn't spend time on, which again can warrant its own slide in discussion, is data. Because you may have a model that's based on, we're going to collect all this data. And the data is going to be really valuable because we're going to get all these insights from it. And from these insights, we're going to be able to make recommendations or do this and that. And the truth that, what I would say on data is often the best form of protection on data and databases can simply be, it's going to be our trade secret. We're going to compile all this data, and it's going to be trade secret. We're not going to share it broadly. There might be very limited cases where we license part of it, but we're going to learn our insights with it, and we're going to share those insights through a service, like run something like Waze, where we have a service, we have all this data about traffic, and people will come to us and use Waze because we are the best place to figure out how to get from point A to point B. The last substantive slide I have is just the last thing on, this is important. So we talked a lot about protecting what you're doing, and there were some questions, I think, from Vince Roman and from Ian about like avoiding issues with third-party IP. This is an important thing. So one thing I'll start with, and it's not on here, is some of you may be working, have jobs already. You may be consulting, you may be employees, and it's super important, to the extent you can bifurcate that work life from your life of doing independent projects or doing startups. And if you can avoid taking anything from your employer, and that's really desirable. Because again, it's one of these sort of access things, and that is like, you really don't want any of their stuff. I think as one person put, I like this, which is when you leave your former employer, if they give you like a coffee mug, like that's okay. But like anything else you don't want to take, like it's okay to take the coffee mug, but nothing of any kind of technical nature. So that's one thing, is just sort of avoiding entanglements. And the next thing to think about, where you might have taken things from former employers, or it can be a little tricky also if you're currently working and you're overlapping working on your project, you may want to go look at the IP provisions, because it's certainly going to say in the IP provisions that anything you do in the scope of the work you're doing from your employer is going to be covered. But it might also say, if you do anything that relates to the business or the reasonably anticipated business of the employer, we own it. So, if you're working for a company and you think you're doing something independent in your whatever dorm room, whatever, over the weekend, it may be that the way the provision is written, it could actually kind of extend in. So it's just smart to be careful about that and actually understand when you sign these agreements with someone who's hiring you to understand exactly what's in and out of what you're agreeing to assign to them. Because if you're going to work for a funded company or big company to do any kind of technical development work, they're absolutely going to be asking you to sign an agreement, which includes that in there. And then, you know, sort of very generally receiving other elements from other parties. We've talked a lot about that, you know, already, like getting stuff from GitHub and looking at that. Should you do a freedom to operate analysis? What a freedom to operate analysis means is that you'll go and you'll look to see what patents are filed. And what I'd say is that in just people who are developing software and apps generally are not doing, you know, much of this research. If people are developing drugs, they absolutely are. And there's somewhere in between where it can be very helpful to know. There's a little bit of a double-edged sword here. It can be super helpful to know ahead of time if there's patents there, because as we saw, you'll see it and you'll figure out how to design around it. Because you'll look at the claims and say, okay, these guys have a patent. And one thing also to assume is if you see claims in a patent application, the issued patent may be different. So you have to see what happens when the patent gets issued, see what claims they actually get. But when you see the claims, you can, you know, work to design around it. There is something where if you know there's a patent out there and you willfully violate it, the damages are worse. But I would say that that's really sort of remote that you're going to get into that situation. And having the knowledge at the beginning is probably better to have that knowledge. You know, if you find something that's directly in your space, or, you know, it could be really simple that you have a competitor that you know that they're doing something similar. You just go search for patents by that company, patents that have been assigned to that company, and see what they have in the space. So any other questions? The last thing is just this is who we are. We're Novus GC. We're in the business of helping early stage companies. And if there is no other question, that will wrap up the presentation.
Well, thank you so much, Rick and Rebecca, for taking time to come out and discuss these issues. We look forward to having you come and do more at the garage down the line. I'm sure that if there are any more questions, you would be happy to field them. I just shoot them over via email within reason. So if anyone's still on the chat, there's about 25 of you, come up with something that you are thinking about. You can email me at vsg@usc.edu. So long as you guys are all on the newsletter, anytime Rick pops into the garage to do another workshop or to talk to our teams and it's an open program, please feel free to come back in and maybe you'll have advanced in your IP journey, which is like an endless thing. Do you have any final words, Rick? Any like last pieces of advice?
No, my only piece of advice is that, and I think it's great. I think the engineering students are on here.
Yeah.
It's like there's lots out there on it. Not everything is correct. It's good to like kind of ground yourself in basics. There's a lot of basics like on the USPTO site. There's like great FAQs on the USPTO site on patents. There's the Copyright Office has FAQs about copyrights. And there's a lot, when you get into open source, that could be its sort of own topic. And maybe that is something maybe we want to do at the garage sometime, is just do an open source workshop sometime. Because
that's a great idea. Because
there's so much, and I know it's like, my guess is half the teams are dealing with it. You know, you're getting code and, you know, it's the basics. Once you kind of understand them, they're actually pretty straightforward in understanding which, you know, there's some open source licenses you want to avoid if you can. And a lot of times people, I think the basic hacker approach is just develop it now and like figure out this stuff later, which, you know, I can't necessarily criticize.
Sometimes works, sometimes.
Yeah.
Well, so again, thank you for coming. You and Rebecca, you've worked so hard in preparing for this, and so I just appreciate your time. And I know we've gone over, so I want to just also say thank you to all the participants for sticking in and learning a little bit more about IP. And I'm going to stop the video now.